not to play the role of CNN, but going back to the Ninth Circuit on Thursday. So I'd be curious about your take on that decision to apply for rehearing on bank. And also, is it a flaw in the Ninth Circuit decision that the statute that Debbie mentioned was not dealt with? Because I don't recall any discussion about that. And also, what will happen if our fearless leader doesn't decide to abide by a court order?
Well, I mean,
you've got 3 minutes.
I'm going to answer the last question first because it's, I think, the easiest one. If the president doesn't abide by the court order, that is the definition of a constitutional crisis. A lot of people now say, we're in a constitutional crisis, but we're not. We're having constitutional conflict. Some parties are playing constitutional hardball. We're not in a constitutional crisis until and unless we have a branch of government refusing to abide by what the court says the law. So that, I think, would be a major crisis. What happens, is anyone's guess. The Ninth Circuit didn't deal with that statute. I think that it deserved some mention, especially in the portion of the decision talking about reviewability. The president says the statute gives him essentially unreviewable discretion to issue this order. The challengers say, but that should be limited by A, the Constitution, and B, the other parts of the statute that say no discrimination. It was at least worth some discussion about whether that provision created an unreviewable discretion. That was only the second.
Well,
what was the first
question?
question?
Have any read about going
back?
As opposed, does that mean there's not going to be a redrafting? And if there were a redrafting of the executive order, how do you think it could be more bold?
I mean, Peter has written about how he thinks the order could be written in a way that would, that would get past at least the problems that have been identified. This would certainly, if they make it clear, it doesn't apply to permanent resident aliens. That, I think, is the easiest. For one thing, it closes off the most salient claims and people who clearly have standing. And then, if they get rid of the exemption for persecuted minority religions, or at least don't do something to make it clear that it only applies to Muslim, then I think that would help them. I think even if they do those two things, the challengers are still going to have a set of valid claims that the purpose is still discriminatory based on religion. Their claims will be maybe weaker at that point. And Peter had some additional thoughts.
I think, Judge, they also should exempt all non-immigrant visa holders. The students, the medical residents, the H-1B employees of the tech companies, those folks have come here, they've been admitted, they've come to rely on the usual appurtenances of a visa, which include the ability to leave the country and then be allowed back in. And I think that's very important to the overall scheme of the Immigration and Nationality Act. After all, we don't just award visas out of the goodness of our hearts. We benefit when foreign doctors come here and treat Americans, when teachers teach, when students from abroad participate in classroom discussions and inform Americans about their thinking and their perspective. So, throwing that in the trash, to me, is contrary to everything that's good about the Immigration Act. And I think that's why you should read in the Immigration Act that distinctions have to be rational, they can't be arbitrary. So I'd like to see the government reflect that. If they don't, then I do think there's a good chance that Justice Kennedy will ultimately weigh in and say, you need to look at the Immigration Act in this more rational way.
Okay, so, we're at our time, so I'm sorry to do that. I like to try and be respectful of people's time. So thank you all very much for coming. Thank you, panelists.